Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights through our incredible online software. Today, we have a fabulous attorney who is one of the most incredible in the state of Ohio, and we're lucky enough to have him today give our webinars in Ohio. And today's webinar's topic is Ohio Notice of Furnishing Lien and Bond Claim Refreshers with Pro Tips. So without further ado, I introduce the fabulous Russell Rorick.
Well, thank you for that wonderful introduction, Ariella. Good morning, everyone. And I usually don't start off laughing, but that's really cool. Anyway, good morning. Our show is going to be real tight here, so you get a real good idea what's going on. If you have any questions, for those of you who aren't familiar with SunRay's programs, in your dashboard that is for GoToWebinar, you'll see toward the bottom something is called chat. If you have any questions, please go right there and look at it. We'll both be watching to make sure that we see anything that come up, and we'll answer them at the end. If you have any problems, certainly let us know too. And I'm a lawyer, and you know, with lawyers is always the fine print. So here's the fine print, and we'll just move on past that and get to the fruit of the program. I use that word fruit because in the legislation, the technical notes in the back of the legislation, it talks about mechanics liens being there for you to be able to secure payment for the fruits of your labor or work. It's kind of like a mortgage on a home. You buy your home, you use a bank, the bank loans you money, and you in turn give them a security interest in your house. Here, you're the lender. You're loaning your money to the contractor you work for, to the subcontractor you work for, to the owner you work for, and you're improving the property of the owner. And so in private mechanics liens, you get to file a lien against the real estate the same way a mortgage is filed against your house. And the whole process to doing that is crazy days. Start your work, obtain the notice of commencement. We'll talk about that in a minute. Serve your notice of furnishing. That's what this whole process is about. That's how it all gets started. And the process of serving your notice of furnishing is deceptively difficult. It looks on its face like it's the really simplest thing to do. When the Ohio law came out in 1991, I looked at it. I'd been doing mechanics liens for a few years already, and I thought, I'm going to have to find a different line of work because everybody's going to get paid and there's not going to be any problems. There are not going to be any more mechanics liens. Well, I think there are fewer mechanics liens, but there's also a whole lot of issues that arise because of improper notices of furnishing. Whether you do it yourself or you have a service do it, there are a lot of services that are just not really on top of it. They try to be a one flavor for the entire United States, and everybody's different. So if you're going to use a service, I highly recommend SunRay because they do it right and take responsibility for it. Where others, like I said, just they try to do it the exact same for California and Texas and Florida and Ohio, and everybody's different. The statutes, mechanics lien laws are creatures of statutes, and the statutes are different from state to state. Along the way, just be careful with lien waivers. They start in your contract, but they also go through every time you get a payment, all kinds of things. That's another webinar, so we won't take a whole lot of time to focus on that. Finish your scope of work, and get paid in full. If you don't get paid, file a mechanics lien. Maybe you're going to file a bond claim or serve a bond claim too, but we'll get to that in just a minute. After you get your mechanics lien paid or filed, then you get paid again or in full, and you release your lien. There's a deadline for serving your notice of furnishing. There used to actually be a too early. There was a really crummy case, a case of bad lawyering and bad judging, I think, in Ohio, that said you can file a notice of furnishing too early. And that's halfway true. And that halfway true is the statute says once a notice of commencement is filed, you can serve your notice of furnishing. Well, the judge misconstrued a whole lot of things because the lawyers did a bad job. And it turned out that you couldn't serve your notice of furnishing until after work started. Well, that changed 3 years ago. We had a case. I wasn't the lawyer on the case, but I wrote the amicus brief on it for the American Subcontractors Association that said what the statute says: you can serve your notice of furnishing at any time after the notice of commencement is filed, up to 21 days after your first date of work on the project. We'll get into that. There's 2 exceptions and 2 exceptions only. That is, if there's no notice of commencement filed, you don't have to serve a notice of furnishing. And if you serve a request for notice of commencement and they don't get it to you in 10 days, you still don't have to do your notice of furnishing. Yeah, right, wrong on both counts. The point of serving a notice of furnishing, the secondary point, is to give you mechanics lien rights. You don't want to file a mechanics lien. You want to get paid. Serving your notice of furnishing gets you on the list to get paid, because what it does is it lets the owner and the contractor, the original contractor, general contractor, know that you're working on the job and that they should be expecting lien waivers from you from the last payment that you got, or from the last payment that they made to the contractor, who made it to the sub, who made it to you, or however that's going to work. So if it works the way the statute anticipates, the general contractor is going to pay you up front. Yeah, I've been doing this for 35 years and it never happened. Anyway, so regardless of what the statute thinks, the way this really should work is you should get regardless of what happens, get your notice of furnishing filed, served, and then do your lien waivers and do them right. Well, like I said, we'll have that in another program upcoming. But regardless of whether there is a notice of commencement filed or they have failed to respond to your request for notice of commencement, get your notice of furnishing done anyway. In fact, the proper way to do it is serve your notice of furnishing at the same time you're doing your request for notice of commencement, because it kills 2 birds with 1 stone. If you're serving your notice of furnishing, you can get it to them, you can serve it on them any way that gets a written receipt. You can serve it on them by sheriff if you want. It says so in the statute. The statute doesn't really prefer that. It prefers that you send it by certified mail. So much so that if you send your notice of furnishing to the address that's listed in the notice of commencement, your notice of furnishing is deemed to be served as of the day you mail it. Everything else in the statute is not the day you mail, but the day it's received. They really like certified mail for notices of furnishing, so do it, do it, do it. Who are you going to serve it on? You have to serve it on, it doesn't matter who you are, you're always going to have to serve it on the owner or the owner's designee. If you are not in direct contract with the original contractor, that's what they call it in this section of the statute. An original contractor is someone who has a contract with the owner. If you're not in direct contract with the original contractor, you always have to serve it on the original contractor too. So at least it's going to be the owner, or if the notice of commencement has an owner's designee, the owner's designee, forget the owner at that point, and serve it on the original contractor. Can you serve it on anybody else? Sure. When I do a notice of furnishing, particularly if it's a good sized job, I serve it on everybody in the chain ahead of my client. So everybody knows I get on everybody's list. That's the important thing. To keep you from having to file a mechanics lien, get on the list. The importance of the notice of commencement. Notice of commencement is a document that this is a quid pro quo, the this for that. When the mechanics lien law changed in 1991, you had to do this notice of furnishing, but that wasn't really fair. And so in its place, Ohio copied Michigan and Florida and kind of glued the two together and shuffled it around a little ourselves and came up with this notice of commencement thing. The notice of commencement tells you, the subcontractor supplier, absolutely everything you ever wanted to know about filing a mechanics lien relative to this particular project. That being a description of the project, the name of the owner. Actually, it's the name of the contracting party, because it doesn't have to be an owner. It could be a lessee. It could be a land contract vendee who is, and not the fee owner, not the, I own this real estate. It's I'm leasing this real estate, or I'm going to own this real estate when I complete my land contract. It'll identify who it is, so you know upon whom you have to serve the notice of furnishing. It may also have an owner's designee. If there's an owner's designee, you must serve the owner's designee in lieu of serving the owner. I serve the owner too. I still want to be on everybody's list. It's an extra $6 for certified mail. Who cares? If it gets you paid, it gets you paid. It also identifies the original contractor, the date the contract was signed. That can be helpful because you get an idea, particularly if this is a project where there's a number of different, this is one construction project, there may be a bunch of projects going on the same site, or there might be a past one, and now there's this one that is more in line with you. And so you can kind of figure out which one you're working on by that. It also tells you if there's a surety, so you might be able to file a bond claim, and it mentions a lender, and it also has, perhaps most importantly, it has the legal description. If you're going to file a lien, you need the right legal description. So bingo, get that notice of commencement. And by the way, sometimes that's easy to find, and sometimes it is almost impossible, and you end up having to try and prove a negative that there wasn't one filed. If you're working on a single family home, one or two family residential project, or a single unit of a condominium, you have 6 days to file a mechanics lien. 6 days. You have 60 days to file a mechanics lien. On everything else, except public or oil and gas, you have 75. So now we've moved away from the notice of furnishing, and we've gotten into actually doing the mechanics lien. Oh, by the way, if you didn't get your notice of furnishing filed on time, remember I said 21 days from your first day of work on the project? Well, it doesn't mean you can't do it. In fact, better late than never. If you haven't done it, let's say you forgot, and it's now day 22. Can you still do it? Sure. The only thing that you lost was 1 day of mechanics lien rights. It kind of, that 21-day window slides along. If you serve it on day 22, you lost day 1. If you serve it on day 100, you lost the first 79 days. It's self-curing to an extent, unless you happen to be a supplier and you served, or you delivered all of your materials to the project on day 1, you serve it on day 22, you really have no lien rights. What if you're absolutely completely out of lien rights? Should you still serve a notice of furnishing? Let's go back to the beginning. What do you want? Do you want mechanics lien rights, or do you want to get on the list? Get on the list. You can still serve it even if you're way late. I've served them on long projects. I've served them, 300 days late, but it's still got them in the line to get paid, and it works really well. So after you get the notice of furnishing done, after you have finished your work, can you serve it early? Yes, you can serve. You can file a mechanics lien early. I almost recommend don't. There's almost no time, unless you just want to kick somebody in the ribs, that you would ever serve a mechanics lien until after you've finished your work. Now, with retainage, on public project or on commercial and public projects, there's always retainage. And I hear people say, well, you filed this lien, you filed it too early, you filed it on everything. I don't owe you the retainage yet, so you have to take that off your lying in your lien. No, that amount is still due. It's just not yet payable. So anytime money is due on a contract, you could file a mechanics lien every day you're working on a job. You could file it every hour if you wanted, because more money becomes due. Ridiculous? Yes, of course. But if you want to cover your retainage, you still have to file within, we're still talking about private projects, and it works the other way too, which is later. You have to file it within the 60 or 75 days. What about the retainage part of it? Well, you still are going to do it. If you want to say, well, I don't want to file for the retainage because it's not due yet, can I hold off? Yes, you can hold off. You'll lose your mechanics lien rights, but you can hold off, because remember I said it's 75 days from the last day of your work, not 75 days from the date the money was due to you. So your retainage may not be payable for a year or more. You still have to file the mechanics lien within 60 or 75 days of your last day of work on the project. Can you fix that? I mean, sometimes you can. I've made arrangements with contractors for my clients who were in a good relationship with each other. The sub didn't want to file a mechanics lien. We went to the contractor and said, give us a change order for a little more work. We'll go out and do it, and we'll get 75 more days. And we've done exactly that. Worked out well for everybody. And now the contractor is really happy with the sub, because the sub is working with them to keep a lien-free job. And everybody is in the better part at that point. If you're going to do a bond claim, first of all, on private projects, there are not always bonds. As a matter of fact, there's almost never bonds. About the only time you see bonds is on a huge private project, or on some of the larger private projects, some public projects too, where you have the prime contractor, the original contractor, the principal contractor, depending on whether you're talking about federal, which is prime contractor, original, which is private, or principal, which is public. Those bonds are going to be there, but there also may be back bonds from subcontractors up. Those will not be listed in the notice of commencement. However, you will find out if you file a bond claim immediately, because if you serve that bond claim on the contractor, the response is going to be, it's an incorrect response, by the way, don't make a bond claim on me. There is a subcontractor's back bond, file your bond claim against that. Okay, we'll do that too, but we're not releasing the bond against you. So they'll give you everything you need to know about filing that bond claim. The rules on filing bond claims on private projects are all by contract. It is not in the statute, so you can't follow the statute at all. You have to read the bond, which is sometimes difficult to get. You'll have to read the bond to know what they are. You may be relying on private or public bond rules. That might be right. It might be completely wrong. So, better safe than sorry. If you don't wait to get to the bond to read it, to file your bond claim, file early and often. Better just to protect yourself and say, I'm sorry later. Okay, let's move on to state and local public construction projects. They're a little different. On notice of furnishing, there's the same general rules, except you never have to serve the owner, because you can't file a lien against the owner's property. it's public property, you can't lien it. What about, what are you going to do? You're going to lien the Justice Center and sell it at foreclosure? I don't think so. What happens in public is the money that is still due from the public authority to the principal contractor is what's liened. So there's no reason to need to serve the owner. I always do anyway. Why? Because they ask for lien waivers. They don't need to, but they always do. So I want you to get on their list. Again, it's $6 more. So just and when I say $6, certified postage. Get it done, get it served on everybody, whether you have to or not. If you forgot and you didn't get the owner, no harm, no foul. If you're in direct contract with the principal contractor, you didn't have to serve a notice on anyone because you don't have to tell the party that you have a contract with that you have a contract with them. Go back to the beginning. Do it anyway. You want to be sure you're on the list of everybody because there's a different set of people who are looking at the contracts from the people who are writing the checks. And you'll also get on the owner's list, which will force the contractor to ask you for a lien waiver, which will force them to pay you. The notice of furnishing is slightly different too, because you're not filing against real estate. So you have to use the right notice of furnishing, one for public and one for private. The notice of commencement, it's very similar. Kind of the big deal differences are there's no notice, there's no legal description because you're not filing against real estate, so you're not going to have that. It'll also show the surety, so you may want that if you're going to file a bond claim too. And it is not filed with the county recorder like private notices of commencement are. Sometimes they are, but it's wrong. So I look anyway. But it is kept on file by the public authority. So you have to wheedle it out of the public authority. They should send it to you just automatically. Sometimes you have to do a public records request because they're, idiots, that's it. But almost everybody, and even in the city of Cleveland, which is sometimes difficult to deal with, we have a good enough relationship with them that we'll get them very easily. So we can sometimes even call if we get the right person, they'll just email it over to us. Other than that, there's no significant difference between the public and the private one. Oh, there's no owner's designee because the owner's not even intended to get a notice of furnishing. Service and filing of the lien. This is opposite. In private, you have to file a mechanics lien within the time limit and then serve it on the owner within 30 days because you're attaching real estate. Here it's the opposite. You're attaching money. So you have to serve it on the owner and then file it within 30 days. So you tell the rest of the world that you have a mechanics lien out there. You want to get it to the owner. If you get it to the owner, they will stop payment to the contractor. They will take the money that they were going to pay to the contractor and put it in an escrow account for you and everybody else who files a lien. So you have to get that order right and you'll be able to secure your money. And you do it, the same way. You serve it by certified mail and you want to be sure to serve it early. And then after that, you file it. If you're going to file a mechanics lien, and we've gone to e-filing in so many counties, the problem with going to e-filing is Cuyahoga County is awful. We e-filed a lien at the end of April. Now, right after we e-filed it, we said they're not going to get it done in time. So we also just had a runner go down and file the lien. We got it back yesterday because it was actually recorded last Friday. So that's a little ridiculous. How much time is that behind? 60, almost 70 days behind in recording. So if you're sending it to Cuyahoga County, I use FedEx a lot to get it to Cuyahoga County because I want to know when they got it. If they have it and they didn't record it and I got it in their hands, I've got some case law that says I can't force them to do their ministerial duty and record it. So if it's a day late, or sometimes later than that, I can prove I got it there, so I can file an affidavit of facts relating to title that can say this is what happened, and it'll actually hook the two together. So you can make up for it. It's going to be really hard because they use a third-party vendor. Cuyahoga does. They use a third-party vendor to get the mechanics lien or any filing in. So it's not, there's no case law in it. So I'm worried about that. So you have on bonds, state and local projects are by statute. You have to file your claim within a year after the project has been accepted, but you have a little standstill. You have to make a claim within 90 days after the project is accepted. So it's accepted, and acceptance doesn't mean using it. It's a legislative act that says public authority accepts it as being final and complete. And you serve that on the owner and contractor, but you already, the real one you're serving it on is the surety. The surety is going to send back a proof of claim. Be sure you respond to the proof of claim. If I do it for you, they send it to me. So I'm a good conduit to get you to do it and make sure your bond claim is good. Federal statute is different. There's a prime contractor there. You have to file suit within 90 days, or after 90 days. There's a little standstill period of after the last work, your work. If you're not in direct contract with their prime contractor, you have to serve a notice of the lien too. You have to make the claim, the bond claim rather. You have to make the bond claim. There are no mechanics liens on federal projects. It's only a Miller Act bond claim. So that's what you need to do. Get your notice out, and now you have a 60-day standstill period, and then you have to file your lien within a year of the final acceptance of the project. That's our story here. I don't see many questions that came up. How do you serve a notice of furnishing if you don't have a copy of the notice of commencement? That's really simple. All you have to do is you get the notice of commencement and you send it to the people there. If you don't get the notice of commencement, you just send a request to the people and they'll send you the notice of commencement. Well, where do you find the people to send it to? You look at the notice of commencement and wait, do you see a circular problem there? Yeah, that's something that the statute really doesn't think about. So you do research. We do all kinds. We call the contractor. If we don't get any good response from the contractor, we look up newspaper articles. If it's public, we go into the public record to see who's on first base and who's doing what, because there's legislative acts that approve contracts, so you can find those in minutes. That's why I say it's deceptively complex, because there's no good way to find a bunch of this stuff. And you either have to use it by doing a whole lot of research or know who is the right person because you've done notices of furnishing on them already and have done it for a while. Like we do a lot of notices of furnishing on Cleveland Clinic. So I already know who they go to. I don't have to do a whole lot of research. We do anyway because they file them and they're pretty easy to identify. I'll give you a little more time to see if there's any more questions. I don't think so, but I'll hand it back to Ariella.
thank you. You did a wonderful job. And if anyone on this webinar has any questions, or you could think of a question, or you thought of the question after the webinar, please don't be nervous. You could certainly send it to us, and we are happy to answer any of your questions. And when in regards to research, that's a very large part of course, what SunRay does, and we help our customers with all of those details. But if there aren't any questions, which it looks like we're good, then Russell, you did a wonderful job. Thank you to all the attendees for attending our webinar, and I wish everyone a sunny day.
Okay, thank you, Ariella.
Thank you very much.